Everyone, and welcome to our next case, Lochner versus New York. This is one of my favorite cases to teach because even though it gets a lot of criticism for how the majority opinion handled the issue in this case, I think there are some really interesting ideas in all three of the opinions. There's a majority opinion and two dissenting opinions, and this is one of the rare instances in which a dissenting opinion is just as important as a majority opinion because all three opinions ended up shaping how discussions of constitutional law happened in the future. So for the exam, I'm just telling you up front, know each of the three opinions sort of equally well, even though normally the advice is the most important opinion is the majority opinion. That being said, let's talk a little bit of background here. Whenever you're encountering a case involving an attempt to regulate part of the economy, the amount of power that a government has depends. And the first thing it depends on is what era of the court are we talking about? Because during different eras, you had different justices with different ideologies and therefore different outlooks on how much power the government would have to regulate the economy. We've read a couple of cases from the Marshall Court where Chief Justice Marshall wanted to ensure that the federal government had the kind of flexibility to choose whatever sort of strategies that it wanted to regulate national economic issues. The court becomes much more conservative at the beginning of the 20th century. We call it the Lochner era because of this case. Now, this case comes in 1905, but we can trace the Lochner era back almost a decade before to 1897. The most important, like I said, overall, you don't need to memorize these dates, but if you're going to memorize one, it would be the year 1937. Because there was a really sort of like sudden and dramatic switch where, believe it or not, I know this sounds far-fetched, because today we have a 6-3 conservative supermajority on the Supreme Court. Well, guess what? The exact same conservative supermajority existed on the Supreme Court in the 1930s. And without there being any change in the court's membership, in 1937, the court just turned on a dime and started upholding pieces of the New Deal. We'll get into that a little bit later because we're going to read like the case that signaled this switch from 1937. But then eventually, those conservative justices retire or die and are replaced with liberal ones. Even Republican presidents end up appointing moderate to liberal justices up until the mid-90s. When the sort of modern conservative era of the court began. And we're also going to read the case in 1995 that sort of signals that transition. You need to know like what point in history are we talking about. Again, the exact dates don't matter. Just know, early in the country's history, early in the 20th century, then something important happened in 1937, and then sort of from the 90s onwards, the court became more conservative. If you have that memorized, you're fine. And then, of course, the other thing you have to keep in mind is how much or what kind of power is assigned to what level of government. So, this is Lochner versus New York. It's a challenge to a state law. And so because it's a state law, you have to consider the nature of a state's police powers. So the authority of New York to make reasonable regulations to promote the health, safety, welfare, and morality of its people. The federal government, it's different. You have to be able to point to an enumerated power, something on the list in Article 1, Section 8. The ones that we're focusing the most time on are the Commerce Clause, and then in a couple of weeks we'll get into the Taxing and Spending Clause as well, because the federal government does spend a lot of money, obviously. But here's the thing. Neither level of government is allowed to infringe an individual right as part of a regulation of the economy. So again, we talked about this in Mugler, but here it is written down for you. This is very important, right? The understanding the nature of state governmental authority. state governments have the ability to promote health, safety, welfare, and morals of its people. The current status of like, I mean, a question I often get asked is like, well, Professor Blake, what if a law has no public health benefits, no public safety benefits, really no public welfare benefits? What if something is just about regulating public morals? Will that fly in the Supreme Court? And today, it's actually those kinds of laws would encounter a much more difficult time because oftentimes what the court has found is that when a state government says, "Oh, we're promoting public morality," really what they're doing is, infringing on the rights of gays and lesbians, or they're trying to be secretive about their white supremacy or something like that. But traditionally, the way we've defined the police powers includes all four goals, and there's usually some overlap, right? That like if you make the public healthier, you're also improving their welfare. And even like something like thou shalt not murder, right? There's a moral component to that, and the going all the way back to the first commandment and whatnot. But guess what? Like the public will be safer if there are few murderers around, right? So it's like it's rare for something to be for some law to only fit into one of these four categories. But that's where the kind of power that state governments have. It doesn't mean that the state can do anything and just point and say, "Oh, well, this is public welfare." The state laws must be reasonable, so that you can like see a connection between what the law is doing and something involving like public safety. You can't just the politicians like lie through their teeth about, oh, no, 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 this law will accomplish this really important goal. It's like, really? No, you have to provide at least some justification, some reason to think that some law as a strategy would accomplish some goal that is about public safety. So that's the requirement for reasonableness. And then, of course, state laws can't step on the toes of the federal government, as we learned in McCulloch versus Maryland. And again, state governments can't take away individual rights. So, what right are we potentially talking about in this case? And that's liberty of contract. And remember, we talked a little bit about substantive due process in the Mugler lecture. And so, this is a particular kind of liberty that was read into the Constitution through the doctrine of substantive due process. And so it's this idea that if you're a grown ass adult, right, you're capable of making your own sort of business decisions without any government interference. Because the thinking is if you if the government intervenes in a dispute between two groups of people and say, okay, group one should have the leg up and group two should be at a disadvantage, that usually means the government is playing favorites. And we don't like the idea of government doing that because, it could seem corrupt in certain circumstances. And so it's better for the government to stay neutral. Now, in the context of like business stuff, government staying neutral means like really sort of like free market capitalism without even the most basic bits of government oversight that we expect today. But that's how the justices treated the Constitution for this period from the beginning of the 1900s through 1937. Is that the state government needs to be hands off. Otherwise, they're playing favorites and they're undermining the maturity of people who, if they're adults, they should be able to make these decisions without the government telling them what their business is, right? So, I mean, that sounds like, the government staying neutral is sort of always going to favor the powerful at the expense of the powerless. But the idea behind the government staying neutral in a dispute between two groups of people, that idea traces its way back to the founding, when if you leave the slave economy to the side, and I know that that's a huge thing to sort of gloss over, but in northern states at least, there was a much greater equality of bargaining power, where like there just weren't as many like big corporations led by wealthy CEOs. It would be like your neighborhood blacksmithing shop, and so if you're like a junior blacksmither, and you're trying to get a job, like the there's just not going to be an ability for all these like small businesses to be like, oh yeah, no, I can. You either work for 10 cents an hour or like good luck finding anywhere else that would hire you. Like if you're dealing with individual workers and small businesses, that it might make sense in those situations because there is more equality in the relative economic power between like a junior blacksmith and a senior blacksmith. Government neutrality makes sense, right? If the two groups in dispute with each other on relatively equal terms, the government tilting the scales to one side does seem like favoritism. Um, but of course, that assumption is you know pretty fantastical after the Industrial Revolution, where you have concentrations of economic power as a result of the growth of corporations. And then there's we also might think that when government stays neutral and allows a powerful group to abuse some sort of vulnerable minority group, that neutrality might actually be, would be worse, right? Would be like a tacit endorsement of that abuse rather than, and the government might have an obligation to step in and protect the vulnerable minority. And we wouldn't say that that intervention was playing favorites. We would say that that kind of intervention would be, just. Um, okay, so the other due process rights, substantive due process rights that were protected around this time included, believe it or not, privacy in marriage. Although by 1937, the like freedom to make your own economic decisions, the liberty of contract doctrine, that got overturned in 1937. That's why, on that first slide, I was like, oh, you don't need to memorize these dates except for this one. That's why. And we'll get to that case next week. Um, but yeah, this same logic of like, grown ass adults don't need the state to tell them who they can or can't marry, right? Like, so that's why marriage is a substantive due process right. It fits the same kind of logic about respecting the autonomy and dignity of adults to make their own decisions, even if sometimes people make, not the best decisions in the world. Um, okay. Again, as you're going through this case, make sure you understand the facts, the issue, the holding, the legal rule, the reasoning, and the theories of interpretation you encounter in that reasoning. But let's get into the facts of this case, or at least how the story is traditionally told about this case. So in 1895, the state of New York passes the Bake Shop Act, and it held that bakery workers couldn't work more than 10 hours a day or 60 hours a week. Also included in the law were sanitation standards in bakeries. And this wasn't really an issue in this case, and these provisions were not struck down. And if anything, the court seemed to speak favorably about the sanitation conditions because working in a bakery in the late 1800s was actually really dangerous. But we'll get into that in a second. So, who's the Lochner guy? His name is Joseph Lochner. He was a German immigrant. He ran a small bakery in a small town in upstate New York. And he basically, he thought the law was unjust. And so, he volunteered to break the law in order to challenge its constitutionality. And he may have gotten his employee, Armand Schmitter, in on it. Schmitter worked for more than 60 hours in a week, and then, ratted out on Lochner, and then the Lochner got arrested and went to court and said, "Well, you can't arrest me because this law that I've been arrested for is unconstitutional." So this is what Lochner's bakery looked like. Just a cute looking sort of mom and pop shop, right? And here's what the part of the first section of the Bake Shop Act looked like. So the issue here in this case is whether a state law limiting work hours in a bakery violates the Due Process Clause of the 14th Amendment. And the court held 5-4 that the law infringes the liberty of contract of workers and bakery owners in violation of the Due Process Clause. Sorry for the typo here. And as I mentioned, there are three opinions. There's Peckham's majority, and then Harlan, John Marshall Harlan, who wrote the majority in Mugler, and then Oliver Wendell Holmes wrote dissents. They're very, very different in the assumptions they make. And they're, like I mentioned, they're all equally important, even though only Peckham had set a precedent by being in the majority. Okay, so the majority opinion starts off by defining what liberty of contract is. And the first case that had sort of hinted that the Constitution included a liberty of contract was in Algier versus Louisiana in 1897. Peckham's opinion says the right to purchase or sell labor is part of the liberty protected by the 14th Amendment, unless there are circumstances which exclude the right. Which makes it sound like he's open to regulating, labor transactions, except he kind of isn't. So the one way in which you might think that working in bakeries provide a legitimate exclusion to the right to sell labor is if you buy the fact that working in bakeries is super, super dangerous. And there was a Supreme Court precedent, Holden versus Hardy, that involved working in coal mines. And the argument there was, well, it's super, super dangerous to work in coal mines. And so you shouldn't work more than 8 hours a day, because otherwise, the dust that you inhale will be bad for your health. And the court in that case, even though the court was very conservative, recognized that for Holden versus Hardy, that that particular kind of employment, mining and smelting, right, and the character of the employees in such kinds of labor were such as to make it reasonable and proper for the state to interfere with the right to work as many hours as you want, because the justices, even though they were conservative, they understood that working in mines is dangerous. However, they are not going to understand how working in bakeries was dangerous. This case is going to be treated differently. The court is going to say that there's a different kind of job involved in a bakery and a different kind of employee as well. So again, as I sort of hinted at in the holding, one really interesting way to understand Peckham's thinking is that the rights of Armand Schmitter are being violated just as much as the rights of Joseph Lochner, even though Lochner, as the business owner, you would assume is the one who benefits more by having workers work lots and lots and lots of hours. But nope, Peckham says, of course, it is the liberty of contract relating to labor includes both parties to it. The one has as much right to purchase, Lochner, as the other has to sell labor, Schmitter. And then who decides whether or not these kinds of rights are being unjustly sort of taken away? And Peckham is going to say, oh, it's got to be up to the courts, right? This is not the question of substituting our judgment for that of the New York legislature. But, we have a job to do, and that's to ensure that the law you passed is properly within the police powers of your state. So is this about public health, safety, welfare, and morality? It says, no. There has to be a limit to the valid exercise of the police power of the state. Otherwise, it would be enough to say that any piece of legislation that was enacted to conserve the morals, the health, or the safety of the people, such legislation would be valid no matter how absolutely without foundation the claim might be. The claim, if you basically tell the legislature, hey, us judges, we're going to uphold whatever you pass, then you're basically giving the legislature the permission to pass laws based on mere pretext, based on a false argument, a false assumption. But you don't know that the assumption is false because courts aren't, in this scenario, courts are duty bound to just sort of like defer to whatever the legislature says. And once you give government the right to pass laws on like a false assumption, that becomes you free the government is free of any constitutional restraints, and the whole point of having constitutions is to ensure that government acts within reasonable rules and limits. So here's the logic of the majority opinion. This isn't about protecting health, safety, health, safety, welfare, or morality. This is a labor law, pure and simple. It is designed to help the laboring class at the direct expense of people who run businesses. And because that is so clearly a government intervention to help one group and hurt another competing group, that's what makes it an interference with the liberty of contract. You need to know this term, a labor law, pure and simple, and know what it means. It means a law designed to help one group, in this case, the laborers, at the expense of another. And we can't allow that because, again, grown-ass men don't need government help. And there's a distinctly like masculine quality to this argument. There, right? So like there's no contention that bakers as a class are not equal in intelligence and capacity to men in other trades or manual occupations, or that they are not able to assert their rights and care for themselves without the protecting arm of the state. These are manly men, these bakers. They can, if they don't like the number of hours they're working, they can burst into their boss's office and say, rah, 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 I want some time off. So they don't need the state to interfere with their independence of judgment and of action. They are in no sense wards of the state. And if you didn't know what the term ward meant, shame on you, because that means you're not a very good Batman fan, right? Because Robin was Bruce Wayne's ward, a child that you were not biologically related to, and yet you are legally obliged to take care of that child. And these are bakers; they are not children. That's the logic. And then it gets even worse, I think, in terms of the assumptions that the opinion makes, right? So, because he's like, well, then this can't be about the health of the bakers, because if you look through the kind of scientific statistics that are going to matter a lot to Justice Harlan in his dissent. And you rank the trade, your jobs from most dangerous to least dangerous, mining is near the top as in terms of like most dangerous. And so it's okay that the government intervenes here. But come on, man, like baking has to be more towards the middle of dangerousness. And so if we allow the government to start interfering and regulating unnecessarily business situations that really aren't dangerous, then no trade, no occupation, no mode of earning one's living could escape this all-pervading power. That's their logic. That's the majority opinion's logic. But you could say that even if this isn't about protecting the health of the bakers, that maybe this is about ensuring that the bread that these bakeries turn out doesn't get the public sick. And here's where, you have to have a special kind of arrogance to write something like this, right? Clean and wholesome bread does not depend upon whether the baker works but 10 hours per day or only 60 hours a week. Dude, how do you know that? Right? You've never worked in a bakery. You probably never even gone to a bakery to buy bread. You probably sent a servant or your wife or something to do that. So how on earth could you possibly know that? It's not like there was some scientific study that was presented to the justices to read about. He just said that, and I don't know, man. I think if I could choose between a loaf of bread baked by someone who only worked an 8-hour day and someone who was working 100 hours a week, I'm probably choosing the guy who worked 8 hours a day. I think that maybe the risk of a public health problem in those situations is a little lower. I don't know. But he distinguishes this because, to Peckham's credit, what he says is there are other parts of the law that are about public health. He says there are several sections that provide for the inspection of the premises where the bakery is carried on, and that's fine. With regard to furnishing proper washrooms and water closets is a fancy way of saying bathrooms, and that's fine. That are apart from the bake room so that you don't have stuff from a toilet infecting like the bakery. That's fine. It's also with regard to providing proper drainage in the bakery and plumbing and painting. That's fine because they go to the full extent of providing for the cleanliness and the healthiness so far as possible of the quarters in which the bakeries are conducted. Like this, if there's a threat to the public health, it's most likely going to be because of the facilities. So those parts of the law are perfectly fine because they are mitigating the danger to the public health. So here's where we get Peckham's test, the criteria he's going to apply to conclude that this law must be struck down. What he says is the mere assertion that the subject relates, though but in a remote degree, to the public health does not necessarily render the enactment valid. In other words, just the government going to court and blurting out that the law, at least to some extent, helps the public health, that's not good enough. The government has to provide a stronger justification than that. The act must have a more direct relation as a means to an end. Like you have to understand clearly how the law as a strategy accomplishes some end goal, and the end itself must be appropriate and legitimate. So the goal that the government is trying to pursue has to be appropriate and legitimate before an act can be held to be valid, which interferes with the power to contract in relation to his own labor. And here's if you want to critique this test, it's pretty subjective, right? Like, he's trying to show that, like, okay, you need a good reason more than just just saying that, oh, it kind of sort of helps. You need to prove your case, if you're the government, a little more strongly than that the law does accomplish a goal. And the way you do that is to prove that there's a direct relationship between how the law works and achieving an end goal. And then you also must be able to justify the end goal as appropriate and legitimate. But proving that something has a direct relationship and that the end goal is appropriate and legitimate, that's pretty subjective, right? And so you end up with a situation where a judge's politics could really end up being the determining factor, right? It allows a judge to be like, yeah, no, I'm pretty sure, just based on my very limited expertise, that clean and wholesome bread does not depend upon whether the baker works but 10 hours a day or 60 hours a week. This was the test that he came up with. He applied it and struck the law down. That got 5 votes, but it really angered some of the justices who were in the minority. And here's the first of the 2 dissenting opinions. This was written by John Marshall Harlan, and he starts off with a very different premise. So he is going to say, look, I agree with Justice Peckham that liberty of contract is a legitimate right. It's a thing. It cannot be violated even under the sanction of direct legislative enactment. But assuming, as according to settled law we may assume, that such liberty of contract is subject to regulations as the state may reasonably prescribe for the common good and well-being of society. He said, it's a right, but not all rights are sort of absolute, especially rights that endanger the well-being of society. Regulations of an individual right in that situation are about protecting society, not oppressing individuals. So the question for the court is, what are the conditions under which the courts may declare such regulations to be null and void, right? So given that, like, we understand there's a right at stake, and we also understand that the state has a responsibility to protect society, and that society might be hurt when people abuse their individual rights. How should the judiciary approach a situation where you have, like, good arguments on either side? And so he comes up with a very different test. He says courts can only strike a law if it has no real or substantial relation to the police powers. or is beyond all question a plain and palpable invasion of rights secured by the fundamental law, constitutional rights. So this is very different, right? Instead of uh, Peckham saying you need more than a mere assertion for a law to be upheld, you need to prove a direct relationship between how the law works and achieving a goal, and that goal must be appropriate and legitimate. Harlan's a little more hands off. He said, if there is no real or substantial relationship between how the law operates and any police power's goal, that's the only time in which the courts can strike things down, because it's more important to protect society than to allow people to enjoy rights with no limitations. Unless the other way the government can strike it down is if it really is not doing anything to protect the public, but is like just palpably invading rights. Right? It has no larger goal to help people. The only way the law works is invading people's rights. So if the law doesn't do anything at all for the police powers, strike it down. If the law only targets individuals for oppression without benefiting society, then the courts can strike it down. But in general, the courts should be ready to uphold laws, even if they attach conditions to the extent to which you can exercise a valid constitutional right. Because it's just better for the legislature to get the benefit of the doubt. Because as he says, if there be doubts as to the validity of the statute, that doubt must be therefore resolved in favor of its validity, and the courts must keep their hands off, leaving the legislature to meet the responsibility for unwise legislation. Right? If politics is important, right? You elect a different legislature, and if they've passed a dumb law, get them to repeal it. Don't go running and crying to the judges. So yeah, it's just a much more lax criteria compared to Peckham. So here's his logic about how we know there is a real or substantial relation between the way the law operates and protecting public health. And it's all sociological jurisprudence, baby. I mean, he just quotes a leading scientist, right? Who writes this book about disease in the workplace, and he's like, yeah, man, working in bakeries is really difficult. It's hard work, physical exertion, you're overheated, unreasonably long hours. But more so because of the erratic demands of the public, compelling the baker to perform the greater part of his work at night. Because when do we tend to buy fresh bread? In the morning, which means in order to provide fresh bread, you have to be baking sort of all night long. In fact, we'll get into this at the very, very end. Then Harlan's this part of Harlan's opinion is directed at Holmes, the one opinion we haven't talked about yet. But Holmes is like, yeah, man, this like what the court is doing is all politics. There's no law here. The court, the majority opinion just has it in for big business. Of course this law should be upheld because there's no such thing as liberty of contract. Liberty of contract is something that conservatives made up to justify, the rich oppressing the poor, right? And Harlan's like, yeah, I don't, I'm not basing my opinion based on whether or not like this is, laissez-faire capitalism run amok or not. All I know is that this law helps mitigate some of the problems of a dangerous profession, and so that's the only that's the only basis on which I'm letting the law be upheld. He says, we judicially know that the question of the number of hours during which a workman should continuously labor has been for a long period and is yet a subject of serious consideration among civilized peoples. Let democracy play itself out, right? And by having those special knowledge of the laws of health, who's better positioned to make those decisions? Legislatures. We're judges. We don't know what it's like to work in bakeries. Legislatures can take testimony, though. They have experts on staff and stuff like that. So they're a much better position to work out a policy. So we should be a little bit hands off. Okay, so now we're on to Oliver Wendell Holmes, who again starts off with a completely different premise. So Peckham says, okay, liberty of contract exists, and it needs to be protected from the to the utmost. Harlan's starting premise is liberty of contract exists, but it's a right that deserves to be limited because an unchecked right to do whatever you wanted economically could endanger society as a whole. Holmes is like, yeah, man, this is not about rights. This has nothing to do with the Constitution. This case is decided upon an economic theory which a large part of the country does not entertain, meaning like really, really libertarian laissez-faire capitalism. And so Holmes says, if it were a question whether I agreed with that theory, I should desire to study it further and long before making my mind up. But I do not conceive that to be my duty because I'm a judge, right? Like whether or not to shift economic policy to be more libertarian, that's something a legislature should do. But as a judge, I strongly believe that my agreement or disagreement about like a basic economic philosophy has nothing to do with the right of a majority to embody their opinions in law. And like, the U.S. Constitution does not embrace a economic theory as whether of paternalism, by which he means like active government intervention in the economy, or the organic relation to the citizen of the state, or of laissez-faire. And so because the Constitution doesn't have an economic philosophy, this whole liberty of contract thing makes absolutely no sense. And the other reason why liberty of contract should not be viewed as a legitimate constitutional right is because we've been restricting people's economic freedoms since the dawn of time, and no one thought to go to court and say, Judge, you're taking away my freedoms. So Sunday laws and usury laws are ancient examples. Sunday laws mean regulating access to alcohol on Sunday. And usury laws, so preventing banks from charging outrageous interest rates. That's been on the books since the Old Testament, right? We know that those laws have existed. A more modern example is the prohibition of lotteries, which was a popular thing that states were doing to prevent people from spending their money in sort of gambling situations. Or every state or municipal institution which takes his money for purposes thought desirable, whether he likes it or not. Every law ends up taking people's money in taxes, and then at least part of that money is going to be spent for something that a citizen doesn't support. It's just inevitable. And you know what? You can't whine and go to court and say, oh, judge, my right to keep all my money is being violated because the government is spending money on some program I don't like. That's nonsense. Government is allowed to do that. That's what politics is for. So here's a really, really, really famous quote. You need to know this for the exam. The 14th Amendment does not enact Mr. Herbert Spencer's social statics. Who was Herbert Spencer? He was a social Darwinist. He thought that he was the one who coined the phrase survival of the fittest. Believe it or not, that was not Darwin himself. He took Darwin's ideas and applied them to the human race, and was really worried about overpopulation and worried about like people from less desirable social classes reproducing at high rates while like really smart people don't have enough kids, and that sort of ugly kinds of sociological stuff. And so like he's accusing, so this is a very sort of like libertarian way of thinking of evolution, and that's just not the point of the 14th Amendment. The whatever liberties the 14th Amendment protects, it doesn't protect you from having an unlimited right to control your labor, because we've been restricting people's economic freedom for thousands of years. So instead, here's Holmes's test. I think the word liberty in the 14th Amendment is perverted when it is held to prevent the natural outcome of a dominant opinion. So, in other words, whatever majority wants to enact in law, that's fine, unless it can be said that a rational and fair man necessarily would admit that the statute proposed would infringe fundamental principles as they have been understood by the traditions of our people and our law. What's interesting about this test is he's not even really sort of saying judges are in charge. He's saying that any person who was reasonable and fair, um, if a reasonable and fair person could be like, oh, yeah, that takes away freedom of speech, then you strike the law down. But if there's any sort of room for debate about whether a law, achieves some sort of social goal, the law should stand. And if the law turns out to be not a great idea, repeal it, via the political process. Um, so yeah, it's what's interesting about this test is it's so tilted in favor of the government. And the ways we know it's so tilted in favor of the government is because it's about sort of uh, whether a man on the street who's reasonable and fair would agree that some sort of law violates a fundamental right. And then the other interesting thing is what's not here. The police powers. There's nothing in here about like, oh well, the law has to be about public safety or public health, right? And you don't even need to don't need to measure the relationship between how the law works as a strategy in achieving one of those health, safety, welfare, or morality goals. It's just like, okay, would a reasonable person say that this law infringes some fundamental right? Okay, there's some room for debate here. Okay, let's let the debate be settled in the halls of the legislature. Get out of court right now. We're done. And so, just like Harlan was like, yeah, we don't need to get into like political criticism here. I'm just going to go through and do my judicial duty and be like, okay, people have a right to control their economic destiny, but the state also has the authority to limit how people how the economy works for the benefit of all. And I'm going to achieve this balance by looking at science to understand how the public health is, or how the health of bakers is being implicated here. Holmes is like, yeah, man, like, I don't need any science. Um, like, I don't need research for a sweeping condemnation can be passed upon the statute before us. A reasonable man might think it proper measure on the score of health. Like, you ask a man on the street, like, hey, it's really hot and dangerous working in a bakery. Do you think it's a good idea to limit how long people work there to 8 hours a day? A reasonable man by like, yeah, that's proper. That sounds like a decent way to make things better for the health of bakers. That's it. That's his test. It's very, 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 very deferential. Whereas Harlan's kind of in the middle, and Peckham is making things very difficult for the government to prevail. Okay, so specific study questions. What I need you to understand is where these three opinions agree and disagree. So, whether liberty of contract exists, two opinions agree: Peckham's majority and Harlan. Holmes disagrees. Should the state get the benefit of the doubt? Peckham says no. Harlan and Holmes say yes. What's the end goal of a law in order for it to pass muster? Peckham says, man, this has got to be a really essential thing involving public health and safety. And Harlan says, yeah, no, so long as it has anything to do with health and safety. But Holmes is like, yeah, no, it doesn't matter if it's about health or safety. Just ask the man on the street whether it's, infringes some fundamental right. And what's the relationship between the law and the end goal in order for the law to be upheld? For Peckham, there has to be a really strong justification in order for the law to pass muster. For Harlan, you have to have a justification. To Holmes, you don't even need to think about how the law works and whether it achieves a goal. So long as it doesn't violate an individual right and it's obvious enough for a man on the street to know that, then the law has to be upheld. If you can work your way through, understanding where these opinions agree and disagree, you're going to do very, very well on the exam. Here's one thing that I want to sort of throw into this discussion. You might, based on the way I had presented things until now, think that Harlan or Holmes have the better of the argument. And let me just say one thing in defense of Rufus Peckham, even though I sort of, I made fun of some of his arguments. But there are serious reasons that there are reasons to take his other parts of his arguments seriously. Because so let's take a wider look at what was going on in the late 1800s. You basically had two types of bakeries operating at that time. You had small family-owned establishments that were largely geared around baking bread, and that was Lochner, right? But then you started to have the development of large unionized factories, and they were aimed at making crackers and cookies eventually. Why? Because they last longer, right? And so if you mass produce all this stuff, you can ship it all over the country, and they won't go bad. So the small bakeries often operated in the cellars of apartment buildings, rundown apartment buildings called tenement houses. Why? Well, that's where you could get the cheapest rent, right? It's already a sort of rundown building, and you needed to be in the basement because only there was the foundation of the building sturdy enough to provide support for like a gigantic oven. If you put it up on like the third floor, the oven would be so heavy it might collapse the ceiling, right? And so what's the consequence of being stuck in a basement of a rundown apartment building? Poor sanitation, no ventilation, no light, no low ceiling height, and all of that means it's extremely hot in the summer and freezing cold in the winter. It's brutal because you have to keep the ovens going 24/7 because if the bulk of your sales are going to be first thing in the morning, that means you're baking all night long. Now you might just say, well, Professor Blake, like, why not let the flames go out, and then restart them like at midnight for the night shift to get ready for the next morning. It takes so long for those ovens to like heat up that it made more sense to keep them on 24/7, even if like the busy time is in the middle of the night and they're not baking as heavily at other times. And to make all of this happen, because these are small businesses and they're not making a ton of money, they're having to resort to like less than ideal places to set up shop. The average baker back then worked 74 hours a week because it's the only way to execute this particular like vision. And so 74 hours in poor sanitation, ventilation, low ceiling height, that's rough, right? So, I mean, we can at least feel like sympathy for these small bakeries. Now, whether we think that like that deserves to have the government intervene and say, no, 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 you can't work this many hours a week or this many hours a day, that's a different question. But here's the thing. It's not just that we should feel perhaps more empathy than at first blush for Joseph Lochner. We also need to take a more skeptical view of the large unionized baking factories. Like they were the ones who were pushing for the Bake Shop Act. So like 3 years before the Bake Shop Act was passed, there was a huge merger that created the National Biscuit Company, which you know today. I guarantee it, right? Except it's not called the National Biscuit Company anymore. It's called Na-Bis-Co, and they make Oreos, right? And Ritz crackers and like all that stuff. And so they're a huge corporation today, and they were back then, right? And so they put the pressure on the New York legislature, passed this law, and it would hurt competition from small bakeries. Why? Because the only way to turn a profit in a lot of these small bakeries is to get people to work crazy, crazy hours. You limit the number of hours, you have to pay more workers, or you have to, shut things down and not operate 24/7, and there goes your profit margin for a small bakery. So you might understand why the corporate leaders of Nabisco want this law, but wouldn't the workers at these at these large biscuit factories, why wouldn't they object? Why wouldn't they sort of stick their neck out in solidarity for people who work at smaller bakeries? Well, the unionized workers at Nabisco and other like cracker companies, they were fine because they were already working 8-hour workdays because they're unionized, and part of like the agreement that they came to with their employers was on their own, like, hey, we're not working more than 8 hours a day. So they had already gotten the benefits of this law before this law was passed. Um, so yeah, these workers weren't going to benefit from anything in the Bake Shop Act, and like small bakery workers were often not unionized, and they were often Jewish. And believe it or not, early unions were horribly racist. So the notion that they would like object to like the corporate leaders of Nabisco putting pressure on the New York legislature, nah, those unionized workers, they were perfectly happy with where they were at. And so, from this perspective, maybe we can sympathize a little bit more with the plight of Joseph Lochner and what happened to him. So I hope you enjoyed this case. I hope it helps with the opinions. If not, I hope you're asking questions. And I'll see you next time.